Dear all, both in person and virtual, thank you very much for attending today's event, jointly organized by Young ICCA and Singapore Very Young Arbitration Practitioners, also known as SG VYAP. We're very excited to have you all here. My name is Gianni Pizzitola, and I'm a Young ICCA regional representative for the United States and current associate at Debevoise and Plimpton in New York. Young ICCA is an arbitration knowledge and skills network consisting of over 16,000 members across 144 jurisdictions for young practitioners dedicated to introducing new practitioners from all corners of the globe to the field of international arbitration. We do this by focusing on four key areas of opportunity for young practitioners: scholarship, skills-based workshops, a mentoring program, and our editorial Young ICCA Voices. If you have any questions about these, or even about Young ICCA in general, please don't hesitate to contact me. I'd love to chat further. We are very pleased to collaborate on this event with SGVYAP. And with that, I'll turn it over to Sunita.
Thank you, Gianni. We are honored to collaborate with Young ICCA on what promises to be a wonderful and insightful event on best practices in international arbitration for junior lawyers. I'm the founder and chair of VYAP and an arbitral assistant to Mr. Michael Lee of Tony Essex. VYAP is part of the global VYAP network, comprising over 25 national chapters across 6 continents. We are run by and for junior lawyers, and we organize events and initiatives aimed at progressing the careers of junior lawyers. I would now like to introduce our stellar panelists. Our first panelist needs no introduction. He is none other than my arbitrator, Michael Lee. Michael is an experienced English arbitrator member of Tony Essex, practicing principally from London and Singapore. Our second panelist also needs no introduction. His name is Cooke, and he is an international arbitration barrister at Reed Smith, where he manages the Singapore office. Our third panelist is Zhu-Wei Lim, who is a senior associate at Herbert Smith, Freehills Prolegis' international arbitration practice. Our fourth panelist is Gianni Pizzitola, who we have heard from earlier. Finally, my co-moderator is Tran, who is a manager at Secretariat and an events director at SGPF. Please note that there will be an audience Q&A round at the end of the panel discussion. You may submit your questions for the panelists via Menti using the code sent to you by email and on the flyer. For those attending in person, you may alternatively raise your hand and ask your questions verbally during the audience Q&A round. Before we begin, we would like to say a special thank you to our generous event sponsor, Herbert Smith, Freehills Prolegis. I'd now like to turn to our first question. Junior lawyers are sometimes given the opportunity to engage in oral advocacy. Could you please share with us your tips for junior lawyers in relation to oral advocacy, particularly for those who are not aware of the differences between oral advocacy in litigation and oral advocacy in arbitration? Michael, grateful for your talk.
Thank you. Thank you for inviting me along tonight. It's a question, the answer to which that does depend a great deal on what cultural background the lawyer comes from. And if you're a common law jurisdiction lawyer, you will have seen cross-examination done, and it's good to follow the example of whoever you sat with, who's been leading the cross-examination. I would say just in 2 or 3 words, whether you're used to a common law background or whether you have a common law background or civil law background, the answer is to relax when you're. It's only a question of questioning a person. More relaxed, self-confident you are, better. And so just don't be afraid of it. That's it, I think, in a nutshell.
Sure. I think just carrying on this role from I think one thing to bear in mind is the origins of your arbitrator in terms of where they train. Now, where I'm coming from is this: in some common law jurisdictions, you have what we call the mean, wrong, and done. The way in which that's applied across different jurisdictions is quite different. So, for instance, and just to get everyone on the same page, the idea there is that if you want to make a submission on a particular fact, you have to challenge it before the witness. You have to put your case to the witness first before you can submit it later on. In Singapore, that's applied more flexibly. So you only have to do that where the fact itself goes to the heart of the matter. When some jurisdictions, Malaysia, for instance, you have to put every fact you want to challenge before the witness. And so that can therefore be extremely time consuming. In arbitration, we don't have to go on ground, well, at least we don't really apply to go on ground done. And if your arbitrator is from that particular trade where we don't apply to go on ground done as rigidly as some other common law jurisdictions, you can end up annoying your arbitrator. So I think that's one thing to bear in mind. Probably also bear in mind it tends to be on a chess clock system in arbitration as well. So you want to be very conservative with the amount of time used for cross-examination.
Gianni?
Yes, I agree with everything. One thing to add, I'd say, is because you're a junior lawyer, it'll likely be your first, maybe second time doing it. I think it takes a while to find your voice. So, and like your personal style. A lot of people develop that having seen a lot of different people do it, either their mentors or people at other firms. So I think just kind of taking it all in and trying to really think what is your best advocacy. It may look different. It may sound different coming from you from someone else. So I think just constantly trying to think about that in light of everything else everyone has said so that it comes out the most persuasive from your voice.
Thank you. My next question is, what are the key areas in which junior lawyers can add value during the document production phase of an arbitration?
I think the short answer is to know your case and be well prepared. Then you know what the issues are, and you can select documents or ask for documents that go to the issue and are not irrelevant.
I would say that the best thing that I've found, at least so far in my career, is really imagining that you are the only lawyer on the case. So like, of course you're going to have a lot of people above you, but like thinking 3 steps ahead, thinking, okay, like I'm going to do the next thing, and then what are the questions I'm probably going to get? What are the people above me? What do they actually need? And thinking through those steps, even just the thought process, makes your initial work product better, and it just makes you a better asset to the team.
Thank you, Gianni.
Thank you. Those are really useful tips on document production phase. Another very interesting component of international arbitration is to work with witness and prepare evidence. So, Mike, do you have any advice for junior lawyers when it comes to this?
Well, I think the first thing is check the jurisdiction in which your witness lives or resides or works, because in some jurisdictions you can't take a witness statement. And I know of a case some time ago now where a partner in an English law firm was put in. He was trying to interview a witness which was contrary to the local law. So that's step number 1. Make sure that you're not going to fall foul of a local law. But assuming that you're being allowed to ask any questions to the witness, I think let the witness tell his or her story in their own words. I think too many times, an arbitrator is faced with a witness statement that quite clearly is not words of that witness. They may be, they may have some reference to what witnesses did. I've just had experience of a witness statement which is 200 pages long, written in English, and when it comes to the hearing, the witness asks for an interpreter. That's fine. He may need to be helped by the interpreter. But the witness statement really straight away told me that that is the party's case just being put into a witness statement. You start off, I think, 15 love down if you have duty. So make sure it's in the witness's words.
Maybe I can continue on theme. So assuming one in prison, you're allowed to statement for your consequences. I think it's appreciate that this is often the role of a junior lawyer to maybe prepare that first draft, then be reviewed by seniors. And I think it's very helpful if you're preparing for exercise to make sure you have a clear understanding of what issues you are actually addressing in the statements. I find witness statements are generally far too long, and they cover matters that actually witness can't probably speak to, because the lawyers are really just advanced in their case through a witness. And you want to avoid that. You've got to be quite technical and say, what are the issues that witness can probably speak to? Because otherwise, you're exposing that witness to cross-examination. And the practical problem is, if you prepare a draft, after, let's say, you interview the witness and you prepare a draft and you give it to the witness, I see time and again, human nature, a witness will look at the draft and they will check it in their mind for accuracy, but they won't think about the issues more broadly. They won't say, well, actually, now I see what you've written for me here, I need to tell you about this or to explain that. That's just not how it works. So the earlier you are scripted and say down a draft, the more dangerous it is. So I would say you go to a first interview the witness with a chronology, you know what happened to you, got in your mind, what are the three issues that witness can speak to? There's that meeting, there's that occasion. I'm going to focus on those three things. And you ask them questions. Now again, when you interview a witness, from their perspective, they have a lawyer coming to talk to them. And again, I think the natural response to most witnesses is to answer the question you tell them and then say nothing else. And that's not really what you want. You want the witness to tell you things. If you're not in a hearing, you're trying to gather the evidence. So when you get more specific answers from the witnesses, you have to focus more on them. You have to ask them lots of questions so they start telling the full context. Because what you don't want to happen is to have a skilled cross-examiner a year later doing exactly that and telling the witness comes out and says that, but they would have told you had you asked the right questions. And I said this to be really, really careful if the witness doesn't want to open up to you. Okay, so I think it's important. The other thing that my question about it goes in looking at a statement and realizing it's not really in the words of the witness, presumably English. Sometimes I see legalese which is that as an arbitrator, you look at them all at what's now. When you have those initial interviews with the witness, they will have some verbal tips they will use. There'll be some phrases, there'll be some shorthands that they use. Now, they don't have industry shorthands. If they use those shorthands, you should replicate that in the witness because it conveys a sense of authenticity. We all know this is not real. We all know that the law is drafted again, but you can at least create an air of authenticity in the witness statement so that when they're on the stand and they use that phrase, funny phrase they use, or that abbreviation that no one knows what it is, if that's in your statement and you've explained it in brackets, whatever it might mean, it will just come across that witness will come across as something authentic. they're more likely to be believed. So I think that's a little thing that you could do. The third thing, as I've been speaking for a little time already, just very briefly, be aware that there's increasing amounts of research done on recollection and memory that tends to show that we don't operate. That's not how the memory works. Memory works, you remember a few key things, and then the brain fills in the gaps. And the problem that poses for us as lawyers trying to prepare evidence is that the way in which you ask will actually influence their own recollection and what they tell you. And so you need to be very careful about how you ask questions so that you're not actually guiding that witness to evidence, which they will then genuinely believe is their recollection. There's loads of interesting research on this in the English, high school, in the business schools, and everyone students with these principles in mind. I really recommend you take half an hour to look at practice direction there, and the guidance notes around that. It's really interesting, but it will change the way in which you try to elicit information from witnesses, make you much more open to ask, and you will get much better quality evidence.
Thank you. So, do you want to add something onto this?
Yeah, I guess 2 points. The first one is technical best practice, building off what we've all discussed about how you draft a witness statement. I think sometimes there's a tendency among junior lawyers to effectively make the witness statement a recitation of the documents. So what you're doing is the witness says, on whatever date this was said, then you put a footnote at the end referring to the document, and you just repeat, rinse and repeat. The witness is adding nothing else to the witness statement apart from reciting what the document is. Now, there's a move in England recently, I think about 2021, where you have Practice Direction 57A right now, which actually tells lawyers not to do such thing with their witness statements. And sometime this year, keep thinking in 2024 still. In sometime in 2024, the English High Court has actually granted an application to get parties to rewrite their witness statement because it fell foul of Practice Direction 57A. So that's something to think about, especially if your arbitrator is from that particular training. The second point is more of a practice management point. And it is that I think that there tends to be an inclination amongst junior lawyers to turn every stone that they can find. And what happens then is the inquiries just go on and on and on. As you find out one thing, you think there are more questions, which then leads to more inquiries. Now, just bear in mind that your witnesses actually have day jobs. They don't do disputes for a living. And there are intra-organizational sensitivities as well, particularly if you're working in a Chinese SOE or a Japanese trading house or another SOE in Southeast Asia. People don't want to raise their hand as I'm the person who did the thing is wrong. And so they will then fight back if you probe too much. Of course, as lawyers, there is a requirement for us to ask the right questions, but do note that if you keep going down the rabbit hole, there's a chance that you may get an unhappy witness and an unhappy client as well. That's just point to know.
Thank you. Gianni, do you have something else to add on?
Yeah, just quickly that I think especially as the junior lawyer, one thing to keep in mind is sometimes the witness is more willing to talk about their feelings with you when they're quote unquote like off camera. And so you're actually like 90% lawyer, 10% therapist. They're nervous, as the other panelists have said, they have day jobs. They're not professional witnesses. And sometimes you get to know them, I think, over the course of the interviews and just the course of the hearing and the prep, and like the submissions. And I think that relationship, you learn more about how they think. So to build off on some of the other answers, like the questions you ask, you kind of cater to the witness so that because once you get to know them, I think the relationship is stronger where you can really get the most out of them and they start to open up. And I think that as a junior lawyer, it's just I think it's a perk of the job. I think every level has its perks, and that's kind of the ones that I've found to be nice. A nice complement to the entire process.
Understood. Moving on to our next question is about interim application. So, Timothy, can you share your advice on how junior lawyers can best assist with interim applications, especially those more challenging ones like security for cost?
Thank you for that question. So, interoperability applications can also take many different types of applications, from the relatively straightforward joint applications, usual, those sorts of things, right, to much more important perhaps and weighted things like security for costs. Now, with all these sorts of applications, when you're grappling with these as a junior, you're starting to prepare, you get a first draft of application. But the thing I think to bear in mind is that, unlike maybe your substantive disputes, the scope of the law or the rules surrounding the application is normally quite well defined. So, in other words, the test of security costs, you will be able to look up by using any book, and the law is not going to be that complex. If you're looking at applications under institutional rules, there is precious little written on those. Really commentary only, nothing really is binding nature. So if you're looking at an SIC drawing application or a solid application, you've got the language to play with, but it's not really a real case to work through. So these are applications which are usually not focused around what the law is, they're heavily focused around the facts. And so these are always good opportunities, assuming you obviously know the rubric of the law you're going to be dealing with. But these are important opportunities for you to learn how to shape to increase the chance of succeeding on applications. And maybe an analog to this is in court practice, so in the common law courts, where you will have summary judgment procedures. Those are, again, applications, yes, there's a lot of law around, what has to attend, but at the end of the day, the law is not complicated, some judgment applications. What you're doing is harnessing the facts to the best of your ability to be able to fit it into the well-known legal test. So one of the things I think, if you are able to have access to doing some court work through litigation, perhaps allows you to go to court, I think it is an invaluable thing to do, to try to get experience doing similar applications. This is partly to give you confidence on your feet, but it's to help you with applications. When I first went out, I was doing some application really nice. And so the law straightforward said every application is like, how do I fit within swinging on whatever it has to be? And you practice that, you then get told up by a judge for doing something, or you see that a particular argument you thought was fantastic does not land at all, so you store it away. So if you are able to have exposure to application in court, I think that's a great way to just develop your confidence and your judgments. Another thing that, unfortunately, there's no shortcut to developing judgment in the job that we do. And of course, at the end of the day, that's really what our clients face, or it's our professional judgment. And it takes time to develop that. So the more dedicated you do, the more you will just pick up what works for the person. So that would be my main thing. And I would then say, if you don't have an opportunity to do court work, or if you do, when you feel it already, you shouldn't be afraid to ask your senior solicitor or partner whether you can have a go in a application, or even part of a application. Maybe there's a two-limb test, and you ask partner, can you do these? And in my experience, arbitrators are very happy to hear submissions from junior counsel. They all understand why you're doing a little application, which is just finding your feet. And in my experience, partners are very happy to do as well. So don't be afraid if I've got this issue on my belt, I drafted with a statement, You know, I know how to argue this. Don't be afraid to ask. You know, you probably will get a very good response.
Thank you, Tim. So, like, what do you think?
Oh, well, I agree with Tim. I think best way for you to assist during applications is really to gain an experience of it. The best way to gain that experience is through baptism of fire, I think. And I echo Tim's point that the best way to do that is to look to your colleagues in different practice areas where interim applications come up more and more. For instance, banking insolvencies, probably a potential candidate, a lot of default judgment, summary judgment applications out there, winding up petitions. And those are small applications which you could assist with. And I think the more applications that you do, the better the mental roadmap that you have in your mind for advocacy will come about. It's also a good way to test the different permutations that you have. And I go Tim's point that, and I can speak for experience, I think judges and arbitrators tend to be a bit more lenient on junior lawyers. So enjoy that while you can.
Got it. So the next question is, if you could go back in time and tell your junior self what to spend your first few years of practice focusing on, what would you say? Mike?
Oh, well, first of all, not sure how far back I can go. But just to say, really, I think in my case, I grew up in a law firm doing general litigation at a time when international arbitration was really confined to shipping, marine arbitration. There was no investment treaty arbitration. And all those things I wish I'd got into earlier than I did. I didn't really get into arbitration until about 25 years ago, I suppose, maybe a bit more, maybe 30. And so that's what if you think of a practice area you want to get into, then do it and make a specialization out of it.
Could you also share with us if you notice any tendencies among junior lawyers that should be remedied?
Sorry, what's the question?
Some common habit or tendency of junior lawyers.
Well, I think it's quite natural for junior lawyers to be nervous and afraid, and you shouldn't be. Because you play a very important part in case preparation, and hopefully you're in an environment where young junior lawyers are encouraged, and don't be afraid to speak up. That's the message. And you don't appearing in an arbitration. Don't be afraid of being asked questions by the arbitrators. Generally speaking, arbitrators are reasonable, and I think these days judges are. Certainly in England, and there was a time when certain judges had terrible reputations of dealing with junior counsel appearing in front of them. But that doesn't exist now. There are rules about how judges should behave, and I think by and large arbitrators behave in the same way.
Thank you. Tim, do you have any advice?
So when I sit as an arbitrator, sometimes see submissions which I have a strong suspicion have been prepared by junior counsel. And the usual telltale sign is an excessive hyperbole in the way things are crafted. So what I mean by that is that arguments are overplayed and more extreme language is used to put forward a position which I think people generally feel is good advocacy, but I think it actually has the opposite effect. So I think it was Stephen King, the author, who said the road to hell is paved with adverbs, and in the context of writing, I think that it's the cautionary message for those of us that have to draft submissions and arbitration. So, for example, if your draft is peppered with words like completely and wholly and extremely, which I'm sure probably all used or using, I would go back after you draft, get out of the system after you draft it and you want it, sleep on it and read it back the next day, and you'll just delete all of it, just get rid of it. It's a great exercise that I give all my students to take one when they first join, when they're first into drafting, is I look at it and I'll say, go back and remove every adverb. And if the argument is not as good, then you need to rework your submission. Because your submission cannot rely on that sort of language. It's actually why I don't think left time, because when you read it, and it's one of these weird things that when you're a junior or when you're a lawyer and do these things, that will come across well. The day you first take an arbitral appointment and you read a submission like that, for some reason you look at it and go, why are they over-emphasizing that point? It's not a good example. So just be aware of that sort of language which feels instinctive like a good thing in it doesn't always come across as well. The other thing I would suggest is this kind of point that you made earlier about turning a very stone. There is a tendency in submissions now to be really very long. No one cares how you put a word process, you can just draft until you fall dead. The problem is that one of our roles as lawyers and as advocates is to know what not to include. So you've got to develop, it's not easy to start with, you've got to develop a filter so that you know what has to be in a submission does not have to be exhaustive. Now, often our concerns are heightened because there's, in most cases, no right to appeal. So if something goes wrong, that's it. So I think there is this innate tendency in a lot of us in arbitration to put more in than we might normally do for fear of, don't raise that point, it's my client can get upset when you lose the client, or not raised about how much chanting didn't mention this particular thing, but like forward 24. There is that tendency just to piece. And maybe that's what you do as a first draft. You get it all down first, but just know how to do it. Because asking arbitrators to read okay, I was reading 270-page document wise. Me, not really happy. Because I was going to take weeks and decide, and I don't think probably could be done far more efficiently if proper thought was gone into doing. But I understand that what happens is you has been told, don't necessarily make sure you cover every single point. But being comprehensive is not the game. It's being able to sit through that and focus on what's really important. So I would suggest on the length, think about not repeating yourself. And if you're drafting a reply submission, I know we all hear this, don't repeat your main case again. Just don't do it. Arbitrators hate it. That's the practical reason why arbitrators absolutely hate it when you're a claimant and your reply just consists of the same argument again. But what happens is, as an arbitrator, you read the claim, and you read the defense, and you've got an idea of, I could easily issue the claim, and I've got a good sense of why the parties don't agree on these particular issues. Then you get a reply document that comes in, and it contains some genuinely important items, so fresh matters that need to be addressed. But they are mingled with a whole load of other comments, which are disguised reiterations of the claim. What I find particularly annoying is that you've got to read that disguised reiteration of the claim to figure out, is there actually something new in it? And then what happens 9 times out of 100, you spend 2.5 hours reading it, and you realise, no, it's just a recycle of the paper. It's really annoying. So again, it's that. I get that kind of, you really want to say the point again, you want to go back to your paper and dig that point in that the defendant and the other respondent, reading. Find a way, again, if it helps, write it all out, make yourself feel better, and the next day, just take account of it. But something like that is good, and generally you will catch it. Trying to never be upset that you file a shorter document.
Thank you. So, what is your thought on this?
So we've talked about personal side of it. We've talked about how you go about the arbitrators. I think the other thing to think about as a junior lawyer is practice management. It's a point that you tend to develop as you get more senior, but I think the earlier you develop it, better. And where I'm coming from, the stakeholder management, there are stakeholders as lawyers. As juniors, you have your senior members of the team, your senior associate partners. The external stakeholders will be your clients. What tends to happen, and I tend to see this across different offices or clients, or owners that we work with. So sometimes junior lawyers can be a bit too eager. What that means is that research memos go into pages. Could just be a short email which only covers 1 or 2 points. If you really think about it, most submissions that you do, the main point that you want to advance can really be made in 1 or 2 cases. You don't need an 8-page long research memo to make a point. The issue there is that cost of the junior doing so has to go somewhere, and that's the client. And so the client will then be faced with looking at your fees, looking at it and go, why does the junior payment so much for research? Someone then has to justify it, or someone then has to justify it right off. And so it's these aspects of practice management that I think people start developing as quickly as they can. That also translates into the way in which you write your emails. Too much legalese, like Tim said, is one of those things. The convertibility of the draft that you give to your senior members to then go on to the client, is it client facing enough? Does it raise all the issues that need to be raised, but raise in a succinct manner? Because remember, especially if you deal with C-suites, they don't have the time to read very long emails. They need something that can internalize very quickly. So it's about thinking about your audience and how you write for your audience and how you do work for your audience, which is a skill that you need to pick up now.
Thank you for all the useful advice. As junior practitioner, it's very important for us to get feedback. Sometimes it is hard to get. So, Mike, what advice do you have for someone who's looking to improve but doesn't get a lot of feedback?
It's a difficult situation, I suppose. If you're in a large firm or most firms, I think these days, there's an opportunity at least once a year to have a chat with the partner who you work for. But that is a more formal process. So I would say never be afraid to ask whoever it is you're working for, whether it's a partner or a senior associate, how am I getting on? Have you got any suggestions for improving my performance? Don't be afraid to do it. If the person you're working for is worth his or her salt, they'll respond to that sort of reaction. And if they don't, then go and work somewhere else.
Yes.
I think there's growth that has happened in that last year, right? Because this job is very much a profession, and there's only so much you can do without requiring some sort of feedback. And that can come from lots of people. It doesn't necessarily have to be a partner who you report to. It could be senior associates. It could be other associates. There's you can ask for advice from lots of different people. But there's also different ways in which you can ask as well. One is at the one end of the scale, as Mike said, often very formal, and the appraisal process where you get to put stuff down in writing in a similar. But at the other end of the spectrum, you could be asked to draft an email advice maybe, and before you press send, you could go to your senior associate partner and say, this is what I think the answer is, this is an email I have prepared. Do you have any advice? Have I got this wrong? Or what do you think? Any tips? You can do it very informally and on an ad hoc basis. And I would say if you've not received formal feedback, or there's people giving you formal feedback, something like a little baby step like that might be a way to start a kind of longer conversation about, I just need some guidance. It could be, I don't understand this research point, or I've been looking for the answer to this research point. I think the answer to this, in this case, but that is this. Am I barking up the wrong tree? And just seeing, it can be as simple as that, very informal. And then the more you do it, the more rapport you create with the person you are trying to develop that sort of relationship with. But it sometimes doesn't work, and there are some firms that do have mentoring programs, sort of formal mentoring programs within their firms, so that you have a mentor who's normally not someone in your practice group, and you can turn to them. That's a very good way of trying to eke out possible feedback, and it could be that you just say to them, I really want feedback. Can you maybe work with them, or I'm doing this, I have no idea whether I'm doing it correctly. What do you think? They may look at themselves, they may ask another associate to help you. There are lots of ways in which you can try to through this problem, and I do appreciate this is a real problem. I've spoken to associates who have this issue when they're going to other funds. So I think I'm just emphasising is on the job training is in place, little bits of feedback, and I think it's so important. And it might be a good way to try to develop sort of mentoring or feedback relationship with your seniors.
Thank you. Lily.
I think it's important to think of feedback very holistically, and that as you develop as a lawyer, more feedback has to come from the bottom up. As much as, and I think that's a part which many people kind of overlook, because as you get more senior, you'll be supervising people more, you'll be managing more teams. You need to make sure that people can understand you and that they understand your instructions. And so that's where I think it's always important as well to make sure that there's upwards feedback in your practice. And that may sometimes become good. You can imagine just running up to a trainee saying, give me feedback on the instructions that I've given you. Obviously, they're going to be so forthcoming there. So one way to do it is to think within the organizations you have. There are a way for anonymous 180 degrees feedback, which you can explore with your HR or with your supervisors. It's the way, there are many ways to go about it, but I think it's important to just get that substance in terms of the feedback that you can get from your juniors.
Those are really helpful tips on getting feedback. Thank you. The next question is for Gianni. What are some traits of a great junior lawyer?
Thanks, Sunita. There's several, I would say. Too many to talk about in this short of time, but I would say kind of three that jump out are just dependability, communication, and the ability to think ahead. Something we talked about a little bit earlier. I think kind of starting with the first, as people who've been practicing for a while, or even a little bit of time know, things move really quickly. So it's very important that when you are working with a junior associate, as the person managing that associate, that you know that just they're dependable. That's being responsive, being thorough in what they do, and just someone that you know you can count on to take the task, run it down, do a good job, and get it back to you in the appropriate amount of time. That kind of goes without saying, but I think it's often overlooked. I think communication is kind of twofold. It's keeping the team as a junior updated on what you're doing and just like checking in on deadlines or like, hey, this thing's taking a little bit longer, 'cause something that happens, right? Like we all run on deadlines as lawyers, but I think often, we say, hey, could you just like make sure we don't have there's no cases on this, or, and then the junior looks in and was like, hey, we didn't think about this, but there's actually this whole thing we need to get into. You're like, okay, that's good for me to know. Thanks for flagging that early. Let's spend an hour on that. And we'll check in. That kind of lack of communication there can really send things off track. So a great junior associate is someone who can really communicate that. And I think the second part of communication is, we talked about this before, but it's like learning how to get to the point despite all the other work that you've done. So just as a quick example, I remember I was like very much baby lawyer, right out, excited, one of my first assignments. I was so proud of myself. I sent this long email to this partner, had everything in there. I was like really proud of it. And the counsel, before even like reading it, just pulled me aside. I was like, hey, great job, kind of. Put that to the bottom. Like that's all good information to have. Summarize that in 2 sentences up top. That's what the partner's going to read. And I'm like, okay. And so ever since then, I did that. I'm really glad that counsel told me that, because it's true. And the work you do should be reviewed. Like it's all good that you've done all that extra work, but it needs to be targeted. And that's just also something you learn from experience. And the last thing is just, the best advice I got from, this is my advisor, when I first started, was just pretend you're the only lawyer on the case. So think through everything. Everything that you do is going to start a reaction above that moves the case forward, and always be thinking that. And what that does is kind of two things. For the case, right, it's obviously good because it gets issues being thought through at an earlier stage from the bottom up, and that helps everyone. But even for yourself, is before you know it, you won't be a junior anymore, and you'll be the one having to move things forward. And just the thought process of doing that every single day on every assignment, even when it's not your direct assignment, gets you in the process of learning how to do that, gets the practice in, the repetition in. And that's what makes you a great lawyer just in general.
Those are some really valuable traits that I'm sure we'll all keep in mind. The next question is, should junior lawyers be scared of damages? Mike?
I think that question should be rephrased. It should be, should any lawyer be afraid of damages? Because there's this thing which I think there's something in the DNA of a lawyer that makes him unable to consider figures. That's not true of a number of people I know, but I think the answer is don't be afraid of it. And I think it's a very useful first step is to read. There are plenty of short articles or textbooks which deal with which set out the basics of accounting. Things like DCF. Those things, you get to know those, so at least when you're talking to the expert, you can know what they're talking about.
I think just building on that, it's no real surprise when you look at the procedural timetable for a hearing. There's 4 days at evidence and 1 day practice with evidence. I think there's just general reluctance to engage with numbers, and it's a bit surprising that even like a narrow issue like interest, and if properly argued, make millions of dollars of differences, a difference in terms of an damages award. So if it is intimidating, like any expert evidence, any expert topic, if it is intimidating, then the first thing to do is to bring up the violence and try to figure out how to have a better understanding of it, because really there is no magic to it. It's just that very often it's unfamiliar, and that may be compounded by concepts that you might have come across before, annoying initials that are meaningless, and all those things which are a barrier to just getting on and understanding what they are. I totally understand I have to have that when I first started practice. But the advantage you have as a junior lawyer is that you're not supposed to know that. And so you should be willing to ask many questions to get you up to speed. And once you get familiar with sorts of topics, you can very quickly realise that actually a lot of the same issues come up time and again. So, for example, in loss of profits, one of the issues when you get your brain to look at loss of profits, how are you going to forecast future profits, what on earth is a discounted cash flow, when you get your terminology in mind and you'll see these specific issues come up, then dive in and figure out how they operate in practice. So I think Global Arbitration Review has a guide to damages. It's quite a useful kind of primer if you're completely unfamiliar, someone asks you to go and look at something. That's not a bad starting point. It's generally quite accessible. So that's something you probably look at. But then you'll need what you need to do though is you need to step back from a primer like that and then figure out what is the political law. Because the political law ultimately is the framework that you to understand damages. But often when experts talk, they don't necessarily talk with those legal frameworks front of mind. But to take that and say, well, under the English law, going back to the invalidate, there are various cases which will help you navigate a couple of issues. So I would say, don't be scared about it. Just grasp an guide and find an easy, naughty guide, a nice simple guide that gets you started, and then follow the rest of that. And then you'll realise before that actually is not there's actually some other really weird concept that we struggle with in us.
I think for anyone who's done quantum proceedings, I don't think I've ever found anyone who really enjoys the quantum proceedings. One reason for that is that it's very specific documents that you need, or specific evidence that you need to make a quantum case. And so quantum submissions can often be very document heavy. Now, the best people to do that kind of work, though, are the junior lawyers. Because while the lead counsel will conceptualize the overall direction of your submission, and the lead expert will do the same, it's really the lead assistants and the junior lawyers who will be sifting through all the quantum evidence and identifying the relevant bits of information that you need. So coming back to the very first question that we had as to how junior lawyers can best contribute to cross-examination or actually be involved in going through the minutiae of documents, the best way in which you can do that. Also, one thing which arises from that is actually finalizing your submissions when trying to figure out how do you convert a particular figure that you have in the quantum report into, let's say, a rationalized figure because it's multi-currency. The best way to do that is actually for the junior lawyer to follow up the lead assistant and just ask, how is it that you read this part of your report? Can you just quickly summarize it for me? Because I'm conscious as well that the lead expert probably is probably in the hearing right now, or doesn't really have time for this at the moment. So that's actually the best way for you to showcase your value proposition as a lawyer. And so I don't think you should be scared of them. I think you should be doing it. That's your way to show yourself.
Gianni?
Yeah, I agree with everything that was said. Just one more quick thing I would say is a lot of us got into disputes law because we care about justice. And I think one thing that's overlooked with damages is, as lawyers, we see damages numbers and it can seem scary, but damages in the quantum phase is an opportunity for lawyers to provide the justice that they think that their client deserves. And I think kind of leaning into that aspect of it makes it a little bit more motivating, enjoyable, and an overall beneficial process.
Really great insights. Thank you. We'd now like to open the floor to the audience. If any of you have any questions, please raise your hands if you're here in person or submit them questions on Zoom.
Hi, good evening. Question was, how would a junior lawyer get over the taboo of not knowing a particular issue or a particular field? So let's say a complex interest question, and we are expected to answer that. How should a junior lawyer convey to the senior that I don't know this and I'm trying to figure it out without fumbling in front of them?
I think the simple answer here is that you're not expected to know everything. And so if you're assessed a piece of research, which is, please look up this compound interest point of the Nigerian law, then what you say is, I'm going to look at that, I'm going to research it, it's not something I'm familiar with, I'm come at you as soon as I can. I think the worst thing you can do is improvise on the spot or pretend that you know more than you do, because you'll probably find out pretty quickly. But I think any partner or senior who's asking a question that is not, explained to me the compensatory principle damages, something very basic, they're asking you to look at it because they need an answer and they don't have the answer what's the way ahead and they're trying to test you. So and I would hope that most people will understand that you're not expected to know everything. Be honest about it. I think what I find is that the more I do this job, the realise the less I know. And I don't think there's any shame in not knowing something.
Thank you.
Sorry, just to add that, I think your question proceeded on the assumption of not wanting to look like a fumbling. I think you should normalize the fact that it's fine to appear that way sometimes. Because if you appear overconfident, it really colors the tone of your answer. And also, I mean, if the concern is about how you approach the conversation, one way to deal with it is really to just discuss it from first principles. If you discuss it from that angle, and you then say, well, these are the areas I do not understand, that's how you then show your senior members of the team. I actually do have a brain here and I'm actually applying it right now. So please don't scold me. If that's your concern, I mean, that's one way of managing it. But I think most senior members will be a lot more forgiving than that if you're forthcoming.
Yeah, I think you have any.
Yeah, I'll just briefly say that I think especially as a junior lawyer, I think this will happen kind of throughout our careers, but pay attention to what's going on in your head. I think the question that junior lawyers tend to have going on in their own heads is, what if I get it wrong? And I think you can change that. And you have to actively do this, but to the confidence point, it's change that from what if I get it wrong to I will figure this out. And then, you don't have to pretend like you know the answer right away. You should be honest with your team, but that doesn't mean that you're not confident. It doesn't mean that you're not going to figure out a way to figure it out. It just means that it's a process. You're honest with yourself and your team about the process, and you're confident that you will get that answer to your team one way or another.
I was just going to say that the one thing that also you'll develop as the more you do this job, you'll get much quicker and have a body of knowledge kind that you will store over time. You'll get much quicker at identifying, well, that's something I really need to know and I need to go on top of. As you get more senior, you'll get instructions to appear and immerse in arbitrations as a one that you have 24 hours to prepare, and you'll get something you know nothing. You'll get better and better at just managing that feeling of, I've got to be ready for this kind of tribunal tomorrow. That comes with time, and maybe the start of that journey is the difficult interest question. But you just say, I don't answer now. I'll come at you. And I think we made a really good point. It's practical knowledge. We can't expect to have all the practical knowledge in the world, but your training, your legal principles, all those things that you do have, you can showcase those. So I don't know the fact, I don't know the answer to that particular issue, but you can still, you know, when I said work for your reason, that shows that well, you see why you're showing that.
Thank you so much to our exceptional panelists, and I also want to thank Gianni for collaborating with us. Also to Herbert, Freehills, Prolegis for sponsoring this event. And I'll now draw the panel discussion to a close. And if you have any further questions for the panelists, you can approach them during the cocktail session, which will take place right after this. Thank you to everyone for attending, and hope you have a lovely evening.